So Roger, this first question, it dropped in during your presentation here, but it is open to our other panelists as well. And Roger, you mentioned the importance of being on the front foot in any arbitration case, but how would one control a lawsuit if the other side moves first and if the other side were to sue you?
I think there is commonly a perception that advantage goes to a plaintiff that they control litigation, but I think I'd mention a couple things. One, where an action is commenced by a plaintiff, a defendant can always consider, for example, if it's a state court, do we have power of removal to a federal court based on diversity of jurisdiction? Which could give the defendant a position where all of a sudden she's turning around and becoming the plaintiff, and the plaintiff is now the defendant. That happened in several large cases we've had that we've been able to accomplish. Secondly, depending on the nature of the case, there can be a discovery priority, the effect of which is to put the plaintiff on hold from seeking certain discovery over a period of 10 or 20 days, say after commencement of the litigation. This will not usually be a tactical advantage to a defendant, but in a case where you're looking at an injunction or something where swift action is necessary, it would allow the defendant to jump in first. And the third thing is, and this really ties in with the program I presented, the whole concept is containing risk. And it doesn't matter if you're a plaintiff or the defendant, your goal is the same, to control it, to control the game. Just like in chess, you could be moving second, you could be black, but your goal is to control the board, and you can. Here, by using the right tools and strategy, you can turn the tables on your opponent, even if they strike first as a plaintiff. Because remember, if you're a plaintiff, when you serve your complaint, what you're really doing is you're creating a target for a defendant. Sometimes the more you say, the weaker your case, and the more targets you give to the other side. So you generally want to be the plaintiff, I think. But if you're not, you sit back as a defendant and say, never mind, I'm going to seize control of this litigation by certain tactical moves, such as we've discussed here earlier today. So that's kind of my quick thought.
Thank you so much. A quick question here for Paul, dropped in during your segment, just asking if a contractor or subcontractor is a defendant and is insolvent or has filed bankruptcy, are there any options available for an owner? What would be the recourse in that set of circumstance?
Usually what happens is if the contractor has filed bankruptcy, what we try and do is locate whether or not that contractor was insured for the project or had insurance. And then what we can do, and what we've done successful, at least in California, is we proceed to the bankruptcy court where the debtor or the contractor is filed, and we make a motion for relief from the automatic stay. Because in bankruptcy court, if a contractor files bankruptcy, the action against that contractor is stopped, it's stayed. But we go to the court and we ask the bankruptcy court for a relief from the automatic stay for the limited purpose of proceeding against the contractor's insurance, so that at least the insurance company can, we can proceed against the insurance company for that bankrupt contractor in the course of the claim. In the event if the contractor is simply insolvent and goes out of business without filing a bankruptcy, we do the same thing. We try and, through discovery, try and locate insurance for that particular insolvent contractor, and we can at least attempt to engage the contractor in the defense and settlement of a claim on behalf of that now insolvent contractor. And so those are the kind of strategies we do. It's a useful, we use both the discovery process to locate potential insurance for an insolvent or bankrupt contractor, and if there's a bankruptcy involved, then we have to proceed to the bankruptcy court and get relief from stay to proceed.
Thank you so much. And Steve, we'll close with a quick question for yourself here, just asking about site inspections. How does one know whether or not they would need a site inspection? And does this have any impact on the speed of an arbitration process? And you know, in light of the COVID-19 pandemic, have there been any sort of impacts on that when it comes to site inspections? Apologies for the person whose question I butchered there, but Steve, whenever you're ready, over to you.
The site inspection, it really depends on the nature of the claim. If you're dealing with a construction defect claim of a significant size, a site inspection is typically very important. You want the arbitrator to see what is going on, especially if you're the claimant. You really want the arbitrator to see. You want to be able to point out, you know, and again, not have the attorneys commandeer the process. Maybe you have your expert point things out, but you want to have the arbitrator get acclimated. In terms of when it's done, I'm not sure I would have a personal preference. As I said earlier, you can do it before hearings, during hearings, or after hearings. The main point of it is you want to convey to the arbitrator before he or she renders their award, so they get to at least consider what they see in terms of that site visit. In terms of COVID-19, the typical thing is going to be everyone is going to obviously have to comply with whatever the local regulations are. Here in New Jersey, there's a whole slew of over 200 executive orders that have been issued that deal with various restrictions about social distancing, wearing masks, how many people could be you know, in one space at one time. These things are naturally changing every day, and they need to be consulted. So you really have to follow what your local law is in terms of restrictions prior to undertaking the site visit.